shuffle this stuff just a little bit. I'm going to try not to impact any of your recording devices. Okay. So, hi. I wanted to have a little press conference today, but partly because there have been, it seems like a significant amount of comments and discussions from a lot of different people, from lawyers, from prognosticators, from bloggers, all those other kinds of things about what it is that the Attorney General's office is doing with regards to a number of cases that we're working on. And so this could be fairly boring. So because I'm going to try and educate you all a little bit about what it is that makes the Attorney General's office different than other politically elected offices in the state. But I think that there will be some bits of information here that you'll find useful, and so hopefully you can stay as long as you like. But I do have some fairly extensive comments to make today, and I'm going to address a number of different cases. I want to start off with, indeed, a little discussion of, and so I actually have notes today. You guys will know I don't normally have notes whenever I talk about these things, but I want to make sure we cover everything. I have, I think, to start off with, a very short discussion about something that I think people have missed, which is that even though I, as the Attorney General, am an elected public official, and so I'm bound by all of those things that we bind our public officials by, I also am the state's attorney. I'm an officer of the court, and I am bound by the canons of legal ethics and by other rules that apply to me and by other court orders that apply to me. So occasionally I think people misunderstand what we're doing in our office because they have a tendency to miss the fact that I am a lawyer. And I just returned from our National AG's meeting, as a matter of fact, and we actually had some discussions about that. These are not issues that are unique to New Mexico. I think that attorneys general in lots of states have a lot of the same issues. They have become interesting in New Mexico from my perspective because I have actually been fairly active and aggressive as the Attorney General in New Mexico, and so there are issues that are being raised in the courts here that are necessarily being raised for the first time in the New Mexico courts that have already been well established in other states, and so I'm going to talk about a few of those. The one thing that I have to remember in trying to ethically represent my client is who my client is. My client is the state of New Mexico. There are a lot of other people that want me to represent them or do things for them or whatever, and we, through the various divisions that we have in the Attorney General's office, quite often are perceived as helping and doing a lot of things for a lot of folks. But I always have to remember that each of my decisions as a lawyer has to be made for what I think is the best interest of the state of New Mexico. What makes that complicated is that quite often there are disparate groups in the state of New Mexico, all of whom are part of the state of New Mexico, who want me to represent them. And as a good example, I talk about when we do our Inspection of Public Records Act training, for instance, I talk about a case where the State Environment Department had a document that they did not perceive as being a public record. We notified them that it was a public record. I won't make this story a long one today. In the long run, they claimed a couple of things, including executive privilege. And the question is, since it's a state agency, is sort of what's my obligation to represent them versus my obligation to represent the position that we felt like it was a public record. In that case, we solved that by commissioning a lawyer in the Environment Department to be a special Attorney General. Because here's a problem. Nobody can represent the state in court except for an Attorney General. And so we commissioned one of their attorneys to be a special Attorney General. And then once the case was filed, we actually intervened on behalf of this public interest group that was applying to get the document to represent them. And so that you wouldn't see that in a normal law firm where you actually have somebody who ostensibly represents the law firm on both sides of the case. And that is, in its simplest form, the problem that we run into occasionally with regard to conflicts of interest in the AG's office. And the courts have recognized that in other states. This is going to be dry work. Lynn, can you get me some water?
I'm doing that right.
Okay, thank you. So as a general comment to start off with, again, I will say that all of you all occasionally get crabby with me because I don't comment a lot on cases, but I feel like part of what a lawyer should do is lawyers actually shouldn't generally be commenting on cases for their clients. The clients normally do that. If you go out to somebody who's represented by a lawyer, quite often you don't really want the lawyer expressing the views of the client unless the client approves those or whatever. And so we don't talk about cases a lot, and I think that has indeed caused some issues. And so I looked at the ethical laws. Thank you. I'm going to take a walk around here. There is a way for me to ethically address some of the issues in these cases, and that way is for me to have an opportunity to refute untrue statements that are made about cases or about facts in the cases or such. And so one of the things that I'm here to do today is to refute a number of untrue allegations that have been made about me and about the Attorney General's office, and that I can do. So that'll be generally the theme for today. I do want to say this, though, particularly in criminal cases, people want the Attorney General's office to be the Rambo for the state, and I actually understand that. I mean, I think that we want to be aggressive in protecting citizens of the state of New Mexico, and we try and do that. But I think that we also have to remember that our office's number one goal, and the oath that I take on the first day of office, is to protect the Constitution of the state of New Mexico. And as you all know, the Constitution of the United States and the Constitution of New Mexico guarantee potential criminal defendants certain rights in court, that it is our obligation, even as we aggressively pursue our cases, to protect those constitutional rights that defendants have in criminal cases. And so I think occasionally some of the things that people perceive in our office are, they might misunderstand because we're doing what we have to do to protect those rights of defendants. And I think that you all would agree, and that everyone would agree, that the person who ought to be the most cognizant of the rights of defendants is the prosecutor. And so we try to do that. All right, so that being said, I will move to the first topic, of which there are several subtopics, but I think everybody is interested. There seem to have been a number of allegations over the last month about our office having conflicts of interest. And so I want to address with some specificity some of those allegations of conflict of interest, and I'm going to try and do them sort of in order. Let me say first off that there are, it seems to become popular in New Mexico for lawyers who are on the other side from the AG's office to allege that we have a conflict of interest. And as I said, one of the things is that for the public that they don't understand is that there are occasionally special rules that apply to attorneys general's offices with regard to conflict. And I think that the lawyers who are out there who are alleging that we have conflict actually understand that. I think that they know that the public doesn't understand that, and that they use that to try and gain some advantage in their criminal trials or in their civil trials. But I'll try and address at least three of the ones that I'm aware of a little bit more specifically. First off, let me quote to you from the New Mexico, and they're the same as the National Rules of Professional Conduct for Lawyers. It's Rule 16-107. And it says, and I'll quote, there may be a conflict if, quote, there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. And so that's the analysis that we apply to decide whether there's a conflict or not. So whenever you all report that somebody says there's a conflict in the Attorney General's office, you know, it would be nice if you would go through that analysis too, but I realize that it's actually my job and not yours to do that. And I will tell you that no matter how unfounded we believe the conflict allegations are, that we always do a conflict analysis within our office whenever those allegations are raised. So here's some of the most notable ones. One is the Region 3 Housing Authority. You're all aware of actually two cases that our office has filed against former legislator Smiley Gallegos and multiple other defendants relating to claims that they misused housing authority money. In that case, the lawyers in both of those cases actually raised allegations of conflict, primarily claiming that our office had civilly represented the SIC, and that because of our civil representation of the SIC in matters that were arguably involved the same fact pattern as the criminal prosecution, that we were foreclosed from prosecuting those criminally. Now, once again, like I said, this is something that only comes up in cases where you have an Attorney General's office because we are one of the only law firms that has civil representation capability and criminal representation capability for one client. In that case, both two district court judges ruled that there were no conflicts and ruled that we could move forward with the trial, but they also allowed those lawyers on what's called an interlocutory appeal to appeal that decision to the New Mexico Court of Appeals. And so those cases were in the New Mexico Court of Appeals for some number of months. People also have criticized our office for not moving these cases along. I'm going to try and give you a flavor for why some of these cases move fairly slowly, but those cases were in the Court of Appeals for some number of months. The Court of Appeals actually then found that there was no reason for us not to proceed with the trial. The defense lawyers then appealed that to the New Mexico Supreme Court. The Supreme Court also fairly recently ruled that there was no reason we couldn't move forward with those trials. So in both of those trials, there's been no finding of conflict on behalf of the Attorney General's office, and we're moving forward with those trials. But we, once again, in protecting the rights of the defendant, have gone through all of the steps that we have to go through. And I think in future cases, either by myself or by other Attorneys General, that the law that's set out by the Court of Appeals and the Supreme Court will be very important in making a determination whether there are conflicts in the future. So I'm not nearly so crabby as some commentators are about how long this takes, because we understand that it needs to be done right the first time, and we're very dedicated to doing this job right the first time. So I think that, frankly, the status of that case right now, and I can talk about the status of cases, I'm not likely to talk about evidence in cases, but the status of that case right now is that we have requested a hearing with the trial judges again in order to set the trial schedule for these. So as soon as we can have hearings with the trial judges, then we will set those trials in Region 3.
Assault. You saw it. We're filing charges.
It's a dry work. The next case that I think people have been interested in has been the case against Rebecca V. Hill-Marone, former Secretary of State, and a number of other defendants, 3 other defendants. In that case, attorneys, there are 4 different defense attorneys. They all raised a number of factual instances that they believe created conflicts of interest. Here's one that is sort of interesting for a couple of reasons. One is, well, factually, let me just say that those motions, the conflict of interest motions, were filed by the defense attorneys very nearly 2 years ago now, about a little more than a year and a half ago. The judge in those cases did not set those motions for hearing right away, and as a matter of fact, you all will know from your reporting that the fact hearings on whether we had a conflict or not were held fairly recently. Now, there's a place where my being an officer of the court doesn't really give me the opportunity to comment on why it took a year or almost a year and a half for the judge to set a hearing on the defendant's motion. But I will certainly tell you that we pretty enthusiastically opposed the defendant's motions. I have a few little backup documents here, and so I have a story from February 13th. I'm trying to see where this is, but it actually is just quotes. It looks like it was in the Albuquerque Journal by Scott Sandlin, but it quotes of the Chief Justice, where in this story he talked about the problems that the courts have with budget cuts. And here's this quote. It says, or actually I think this is out of the article, it says, "From the smallest to the biggest, courts statewide are struggling. The judiciary may be an independent branch of government, but it doesn't set its own budget, has no flexibility to move money around the courts where it's most needed, because lawmakers control funding for each judicial district in the higher courts." Quote from the Chief Justice, "All the laws on the books are just hollow promises if the courts don't have the resources to enforce them." I will tell you, one of the things that might be important to come out of here today is that everybody needs to understand that our court systems are bogging down, and unless the legislature, and I think it's incumbent on citizens of New Mexico to encourage their legislators, unless the legislature adequately funds the courts in the state, that we will continue to have these kinds of problems. In any event, we had a hearing on the issue about whether or not the Attorney General's office had a conflict. This is all information that's in the record, but it's been widely reported that the Attorney General was, I think some of the words that have been used are booted off of the case or removed from the case for various reasons because we had a conflict of interest. I'm going to read you something from the transcript of the judge on the day that he handed down his decision. He talks a little bit about each of the factual allegations that were made, but then finally says, in looking at this cluster of conflicts or purported conflicts, I see no wrongdoing on the part of the Office of the Attorney General. I've worked with Mr. Lackman many, many times. That's my attorney that's pursuing this. I find him to be very adept, very talented at trial, very knowledgeable, and quite easy to work with. I don't see the prosecution coming from a vindictive place. I don't see it being created by any political agenda or by any inter-office agenda that would want to come back and punish either Mrs. Cufford or Ms. Vigil-Herron or any of the other defendants involved. So the factual finding of the court was that there was no conflict by the Attorney General's office, there was no bias, there was no political motivation for pursuing this case. But that gets into what lawyers love to talk about and what we try to do to keep the case on, and I'm going to go on with what he said. He said, but in looking at the issues that are raised, I feel myself in a position where I have to safeguard something much higher than the conflicts I'm seeing here. What I'm tasked with protecting is the integrity of the system. Allegations of government corruption, I think, must be explored in an environment that shines the brightest light on the facts that we can possibly shine. I think the issues that I have just discussed cast shadows on the forum where these issues have to be joined, and I think any time shadows are cast upon this, especially where there are allegations of government corruption, that those shadows have to be removed. And the very clearest light we can find has to be shined on the allegations. One, to achieve justice for the people that are charged, and two, to make sure the community has absolute, complete confidence in what we're doing as a court of law. I think that the judge was expressing what all of us as lawyers work with and struggle with, which is the discussion of what constitutes an appearance of impropriety. Lawyers try and avoid the appearance of impropriety. But I will tell you that as a result of this decision by the judge, I had two choices that I could make. One would be to appeal the judge's decision, basically argue to the appellate courts that there was no finding of conflict and we should move forward. You all, if you look at the time schedule in the Region 3 case, then would understand that that appeal would take me a year or a year and a half. Or I could make a decision to agree that the judge had raised an issue that we should think about and that it was appropriate to decline this case to some other lawyer. And so that's what we decided to do. We decided to decline this case, and you all know by now that we declined this case to the district attorney in the 2nd District. And then now there have been some discussions about how long that's taken or how fast that moves. But here's where being an elected official causes some issues with my being a lawyer. We would have loved to have just gone out and hired a special independent prosecutor and stick them on the case. When we looked at the law in the state of New Mexico, we found that the Attorney General's office does not have the authority to hire an independent prosecutor. So we'll take that up with the legislature, but we couldn't directly hire a lawyer. So it turns out that the district attorneys do have the authority to hire independent prosecutors. And so we immediately started working with and negotiating with a couple of the district attorneys to see who would be able to manage this case by taking it over and doing that. And you all know, if you've looked at the pleadings in the case, that we have a memorandum of understanding with the 2nd District Attorney's Office. Our office is going to continue to pay the freight because, once again, budget issues have made it such that the 2nd District Attorney's Office can't do this on their own budget. They don't have additional budget to take on a case of this magnitude. And so we have set aside the money that it'll take to complete this case. So there you have seen, I'll make a little sidebar here because you've seen that one of the defense attorneys has filed what we call a speedy trial motion, claiming that it's been 77 days, more or less, or actually I think some analysts came up with the 77-day number, and that somehow or another that is going to cause his client not to have a fair trial because it's not a speedy trial. Once again, I will just point out that the motion that the defense attorney filed that led us to this point, it took about 400 and some days before there was a decision made on that motion. And so rather difficult to ascertain where the real argument is when the defense has delayed the case for 400 and some days, and they're complaining that it's taken 70 days to do this. But we are, in the Attorney General's office, bound by the procurement code and by these other laws. And so we are procuring a lawyer through the procurement code, and there's no way to shortcut that, and I think that the judge will understand that. But the judge will make his decisions on whether what we're doing is speedy or not. And But I would encourage folks who are writing their stories based on just the allegations of the defense attorneys that you should remember that there are two sides in all of these cases, and it would be worthwhile to read our pleadings as well as the defense pleadings when you report on these cases. Okay. So here's the third one. This is the one that seems to be the most interesting right now, and these are allegations raised by Attorney Victor Marshall relating to whether or not our office has a conflict of interest in a civil trial. And in order to understand that one, I think that you need to have a little information on how that civil trial came about. The cases that were brought by Mr. Marshall are brought under what's called the New Mexico Fraud Against Taxpayer Act. It is what lawyers call a key tam statute, a whistleblower statute or a bounty hunter statute. These are statutes that date back, the first federal statute dated back to the time of the Civil War, where unscrupulous dealers were selling beef to, I believe, to the Union Army, and they were selling them bad beef. And so the Congress actually passed this law that allowed certain civil lawsuits to be brought ostensibly on behalf of the state, of the country, but by private lawyers. And that's essentially what we have in our Fraud Against Taxpayers Act. It was passed in 2007. It actually was part of the Attorney General's package that we brought to the legislature to encourage them to do that. We think it's an important and powerful tool that can be used in fighting corruption in the state of New Mexico. It has some flaws, which I will relate to here in a couple of minutes, but it is on its face a case that's brought on behalf of a relator, in these cases Mr. Foy, on behalf of the state of New Mexico. They say state XRL, which is what lawyers use for those. And those two cases, one of them, the Vanderbilt case was filed by Mr. Marshall on July 14th, 2008, and the Austin case was filed on April 17th, 2009. And I think what has led us to the place where we are here is that recently our office filed motions to dismiss significant portions of these two fraud against taxpayer cases, and we have been criticized for doing that. But I want to try and explain to you today why we did it, and you all will then have an opportunity to make a decision whether you think that was in the best interest of the state or not in the best interest of the state. One of the things that's important to note about both of those cases, I think, and they're not cases that we have pursued, they're brought by Mr. Marshall on behalf of his client, is that both of those cases are still in the pleading stage. No discovery has been done, so after 2 years or more in those two cases, there hasn't been any progress in those cases. There is only one substantive finding from those cases, in both of those cases by the courts, and those findings have been that the act itself does not apply to any damages that the state might have prior to the passage of the act in 2007. And that's going to be important to understand why we did what we did, but just remember that date, 2007. There is a flaw in the New Mexico Fraud Against Taxpayers law. It does not require that the relator have actual knowledge of the fraud. And I know that sounds like a lawyer term, but what it means is that the whistleblower, the person that files the case, could have possibly just read about the case in the newspaper, and they can go hire a lawyer and bring that case. That is not true for other key tam statutes, and we have for the last 2 years been working with the legislature to fix that flaw, but have been unsuccessful. So it has related or has resulted in a lot of cases being brought under the New Mexico Fraud Against Taxpayers Act, including probably about 100 cases brought in jurisdictions outside the state of New Mexico. Our law is considered by plaintiffs' attorneys to be such a broad law that if they can find a way to implicate it in cases in California or in Texas or somewhere else, they will do that. And so when you see stories that say that we have 100 fraud against taxpayer cases in the AG's office, actually now we probably have 130 or so that I'm aware of. A lot of those are cases where the state law has been implicated in other actions because you could consider it, if you're the plaintiff's attorney, to be a very powerful tool. One of the drawbacks of that is that if you file a case based on something that you read in the newspaper and you don't have a lot of other facts to back that up, it makes it a difficult case to pursue. So I won't comment on whether it's good or bad, but it makes it a very difficult case to pursue because you don't actually have any facts. And you have to depend on being able to go out and either through discovery or through some Perry Mason moment where somebody just says, I did it, that you'll move forward in your case. So we actually have felt like those cases were kind of languishing. We have been working for a couple of years with Mr. Moise, the new state investment officer, and with the board in order to try and think of more effective ways that we can work to get the state's money back. This year, our state legislature passed a law that gave the SIC the authority to directly hire a law firm to represent them in such cases as this. And so pursuant to that, the SIC and the Attorney General's office did a request for proposal. We hired a firm called Dave Pitney, who has had great success in recovering monies on behalf of the state of New York to represent the state of New Mexico. And we filed cases on behalf of the state of New Mexico that include claims prior to 2007 for damages on behalf of the state of New Mexico using theories that are not the theories of the Fraud Against Taxpayer Act, but more standard common law theories for why these things caused damage to the state. After that, after we filed those lawsuits that reach back past 2007 on behalf of the state of New Mexico, then we filed motions to dismiss the parts of the Fraud Against Taxpayers Act that covered the same ground as the cases that were filed by the SIC. And that triggered a series of events that culminated in a press conference by Mr. Marshall, where he accused me of having a conflict of interest. So now we're back talking about conflict of interest. But I will say this, you all, you can mine from the pleadings whether you think these cases are good cases or bad cases or whatever. It's difficult for me to talk about them. But the decisions that we made, both to file the lawsuits on behalf of the SIC and to limit the fraud against taxpayer cases, are cases that I believe are in the best interest of the state of New Mexico. They probably are not in the best interest of Mr. Marshall or Mr. Foy. And so even though there's a fiction in the Fraud Against Taxpayers Act that Mr. Foy and Mr. Marshall are representing the state of New Mexico, I think that you will see as you analyze this that they are certainly looking out for the best interests of Mr. Foy and Mr. Marshall. To the extent that that's good for the state of New Mexico, then that will be good for all of us. So let's address Mr. Marshall's, seems like his primary complaint of the fact that our office has a conflict of interest because Bruce Malott, who is a defendant in part of the Fraud Against Taxpayer case, was my treasurer in my congressional campaign. Once again, I think that it's easy to sort of make that allegation. Okay, well, yeah, it seems like Mr. Malott and Mr. King, they must know each other pretty well because he was his treasurer, and so wouldn't we want to at least think about that and think about whether it presents a conflict? And that is all true, and we thought about this, we have looked at this. Let me tell you a couple of facts that don't seem to have been brought out in anything else. One is that you would assume from looking at campaigns in New Mexico, a lot of times the campaign treasurer is a close friend or a big fundraiser or a big financial supporter of the candidate. In this case, Mr. Malott was none of those things. When I ran for Congress, the DCCC, the Democratic Congressional Campaign Committee, recommended to me that I not use a friend or a big supporter or somebody like that to be the treasurer, that I use somebody who had experience in being the treasurer in federal campaigns. And Mr. Malott is certainly that. If you go back and look, he has his firm, because of his accounting ability, have been campaign treasurers for a number of federal campaigns and understand all the FEC laws and such. And he did a very capable job as my campaign treasurer. But when you do the conflict analysis, and I could go back and read 16107, but I won't, and look at these cases, you will note that Mr. Malott is not a defendant in any of the cases that were brought on behalf of the state of New Mexico by the SIC. He was not a defendant in any of the parts of the Fraud Against Taxpayers claim that we are dismissing on behalf of the state. He is a defendant in the part of the Fraud Against Taxpayers claim that involves the ERB that we have left intact for Mr. Marshall and Mr. Foy to pursue. So number one, the first important point in doing the conflict analysis is that Mr. Malott is not a party in any of the cases that our office has been involved in. So it's impossible for there to be a conflict. Secondarily, Mr. Malott was never a client of mine. He was never a former client of mine. He was never a close personal friend of mine, so that goes to that issue about whether or not there might be some other problems there. And so the only thing that's left is sort of Mr. Marshall's bare allegation that because he had some function on my campaign, that creates a conflict of interest. I think if you look at Rule 6107, you will see that it does not. create a conflict of interest. And frankly, the history of our office has showed by our prosecution of Rebecca V. Hilderon and Smiley Gallegos, who was in the legislature with me, and other defendants in a lot of those cases, that we are not afraid to prosecute or pursue actions against somebody just because I know them politically or something else. And so I think it really, maybe this is the crux of why I called you all here. I think that the public is not well served by either the allegations of or speculation about whether or not anybody that ever gave a political contribution or supported a candidate or something like that generates a conflict of interest, because all of us who are prosecutors, myself and the district attorneys, are all elected officials. It's the way our Constitution decided to do that. And so if I allowed everybody to knock me off of a case just by alleging that I had some interest or conflict of interest, I wouldn't be a very good attorney general or a very good prosecutor. I think that we cannot tuck and run every time an attorney who doesn't like what I'm doing to their client makes an allegation that I've done something wrong. And I don't intend to do that. And so people will speculate as to whatever they want to speculate with, but I'm here today to tell you that we do that analysis. If there was truly a conflict of interest there, we would, in whatever way was necessary, refer those cases or do something else with them. Another little sidebar on the FEC issue, by the way. There are allegations that I used Mr. Malot's name on my reports for a number of years after he said that he was not my campaign treasurer anymore. That I think probably, and I haven't had a chance to talk to Mr. Malott, but I think it probably is more a misunderstanding than anything else. I recall having a phone conversation with Mr. Malott where I basically said, look, the campaign is not accepting checks anymore. The only bill that's outstanding that we have to pay is, if you follow federal races, you will note that the federal candidates can only loan money, their own personal money to the campaign, or they can get a loan from a bank. You all will know that my mom and dad supported me greatly when I was running for any office, but federal rules do not allow you to borrow money from your parents. So I never got any loans from my parents. I got a loan from Wells Fargo Bank. And so for 3 years after the campaign was over, I had to continue to pay off that loan. And so every month, I had to report to the FEC that I made a payment on that loan. So a number of years ago, I had a conversation with Mr. Malott where I said, I can send these reports on to you, you can file them, but it is pro forma. I make the payment, I report it on the report. The reports are all done on